The case is not about the label. The case is about what the symptoms are and were those symptoms caused by the crash or the event, and what does the future hold.
TBI cases can feel like navigating uncharted territory. Your client's injury is real, but proving it, that's where the real challenge begins. If you've ever felt like you're missing crucial pieces of the puzzle, you're in the right place. Welcome to Winning the TBI Case, where Tom Crosley shares the insights he's gained from over 60 injury trials. Not just the victories, but the lessons learned along the way that make all the difference. This is practical wisdom from someone who's been in your shoes and found a path forward. Winning the TBI Case. Strategy, science, and storytelling.
Let's join Tom as he breaks down the fundamental challenges of representing clients with invisible injuries.
Welcome back to Winning the TBI Case. I'm Tom Crosley. And today I want to talk about how mild traumatic brain injury gets defined. And this can become clunky in a hurry. And I don't want it to turn into a word game instead of a useful discussion. So I'm going to try to keep this simple and practical. Here's the main point. Definitions matter, but they are not the whole case. A case does not rise or fall just because one expert wants to call it a mild TBI and another wants to call it something else. At the end of the day, the real questions are still the same. What happened in the traumatic event? What symptoms and impairments followed to your client as a result of that? Were those problems caused by the event? That's where the case lives. How do these problems affect that person going forward in life? What does the future hold for this person? It's not what label we attach to the injury. It's was the injury caused by the event. So if a person develops headaches, dizziness, cognitive problems, balance trouble, light sensitivity, fatigue, irritability, and inability to function the way they used to function, those are always going to be real problems, regardless of whether a defense expert wants to claim that it's not a mild TBI. So why then do definitions matter? They matter for two reasons. First, the better you understand the definitions of mild TBI, the better equipped you are to read the records, evaluate the experts, and keep your case grounded in sound medicine. The better able you are to avoid getting sidetracked by defense wordplay and semantic games. Second, medical literature is built on definitions. Researchers define who counts as a mild TBI and who does not, and then they study recovery, prognosis, treatment, long-term outcomes based on that defined group. So if you don't understand the definition that they're using, you probably don't fully understand the literature either. So before I go further, let me say one quick word about the American Congress of Rehabilitation Medicine, the ACRM, because we're studying and relying upon the ACRM definitions here. The ACRM is a major interdisciplinary rehab organization focused on research and evidence-based clinical practice. Its brain injury work has long been considered mainstream for over 3 decades. When the ACRM publishes something on TBI, lawyers should understand that this is important and widely respected. It's not some fringe view. So let's talk about the 1993 ACRM definition of mild TBI, which for decades was the classic definition of mild TBI. It said that mild traumatic brain injury is a traumatically induced disruption of brain function shown by one of 4 things. Loss of consciousness, anywhere from 0 minutes all the way up to 30 minutes. Beyond 30, it becomes moderate. Loss of memory around the event, so amnesia, as long as the amnesia resolves within 24 hours. If you have amnesia for more than a day after the event, they're calling that moderate also. A 4th thing that will fit is focal neurologic deficits. It just means some kind of localized neurologic abnormality. Examples would include weakness or numbness on one side, facial droop, slurred speech, abnormal pupillary response, a visual field cut, impaired coordination in an arm or a leg. Those are pretty unusual, at least in my handling of these cases when I'm looking at medical records, and we tend to see altered consciousness. Even if the person is not unconscious, we see altered mental status, dazed, confused, etc. Rarely do I see a ER documentation of a focal neurologic deficit. But it's important to know what that means. So the 1993 definition mattered because it gave medicine kind of a common agreement point. The problem is, over time, that got messy. Different specialties started using different approaches. Sports medicine came up with its own definition. Emergency medicine came up with another. The American Academy of Neurology came up with a different one. The neurosurgeons came up with a different one. So the ACRM got together leading up to 2023 and said, hey, we need to fix this and have one universal definition that we can all kind of rely on. It was an effort to bring more order and consistency to the diagnosis of mild TBI. You probably ought to read it. It's 6 criteria. It's 3 different pathways, but it's really easy to get lost there. So I try to boil it down. And if I'm going to teach it to a jury, I'm going to try to boil it down as basically as possible. That's what I'm going to try to do for you in this episode. I'll leave it to you to let me know whether I succeeded or not. But here's how I boil it down. Under the 2023 framework, there first has to be a plausible mechanism of injury, some kind of event capable of transmitting force to the brain. It could be a blow to the head. It could be the head striking an object. It could be acceleration, deceleration from a crash. It could be a blast wave, concussion type force. But once you have the plausible mechanism, there are basically 3 ways to get to the diagnosis. The first way is some obvious clinical signs. It's the easiest one to understand. You have the injury event, and then you have obvious clinical signs of acute brain dysfunction. This route feels similar to the old 1993 definition. The second way of 3 that we get there, without obvious clinical signs, we get there with symptoms plus objective support. So not every legitimate mild TBI comes with a nice, clean witness account or a perfect ER note saying that the patient was definitely confused and repetitive at the scene. Real cases are often messier than that. Sometimes the person has the classic early symptoms: headache, dizziness, nausea, light sensitivity, brain fog, trouble concentrating, irritability. And sometimes those symptoms are backed up by objective findings on examination, such as abnormal balance, some kind of abnormal oculomotor testing, some kind of vestibular issue, an abnormal cognitive screen. So if you have some of those symptoms, 2 or more, and you have some kind of objective medical screen, then that is how you get there. The third way you get there is abnormal structural imaging. That means a CT scan, usually done in the ER, which, as we know in these cases, is most often normal. The other way we get there is a structural MRI that shows some kind of intracranial abnormality that's related to trauma. That's the imaging route. So let me be very clear here. Positive imaging is not required to diagnose a mild TBI, has never been. Most mild TBIs do not show up on routine CT or MRI, but when they do show up on CT or structural MRI, that supports the diagnosis directly. And a lot of times, depending on what the abnormality is, it may move it beyond the mild realm into the moderate realm. I'm going to leave advanced neuroimaging for another episode and keep today's focus on the core diagnostic framework for the 2023 ACRM definition. That's the simplified update. Number 1, a plausible mechanism of injury, and one of 3 routes: either obvious clinical signs or early symptoms, may or may not be documented in the medical record, plus some objective support documented in the medical record. Abnormal neurocognitive screen or balance issues or something like that. Obviously, some kind of abnormality on CT or structural MRI. That's the cleanest way I know of to teach this to a jury. Why do lawyers need to know this? It's not because the entire case turns on the label. The case is not about the label. The case is about what the symptoms are and were those symptoms caused by the crash or the event. And what does the future hold? So when an expert comes in and says, oh, this does not meet the definition of mild TBI, this is not a TBI, it's missing XYZ, I don't think that matters that much. Plus, your own experts are probably already laying the groundwork before the defense expert comes in, talking about why it is a TBI. The symptoms are still there, the impairments are still there, and you've answered the causation question. Why do we need to know what the definitions are? Knowing definitions helps in several ways. First, it helps you read the records with more sophistication. It helps you evaluate experts and see whether they're applying mainstream medicine or just kind of narrowing the terms. It helps you understand the literature because prognosis studies and outcome studies depend upon how a patient group was defined. And fourth, it helps you from getting dragged into the defense wordplay and semantic games. So when the defense says, this is not TBI, you can catch them playing with these definitions in a way to try to move your case out of the realm of injury. So the next question, if it's not TBI, then what is it, right? The defense is usually saying, well, it's made up or it's psychological. And many times I can get defense experts to admit that the impairments are real for the patient. And the impairments were brought about by the event. So regardless of whether we call it a TBI or something else, it's still a compensable injury. And so that's where we're trying to get our case to live. So here's my final takeaway. In 1993, the ACRM definition gave us the classic framework: loss of consciousness, amnesia, altered mental status. The 2023 update kept in the spirit of that definition, but it made the diagnosis more structured and more realistic for modern practice. So if you want to teach it to a jury, don't get bogged down in 6 criteria and 3 pathways. Instead, understand those 6 criteria and 3 pathways, but teach it this way. Number 1, there has to be a plausible injury mechanism. There was in this case, the car crash, whatever the event was. There have to be clinical signs. There were in this case, and list them. There have to be symptoms. There were in this case. What were they? Dazed, confused, disoriented, headache, etc. Or there has to be trauma-related abnormality on CT or MRI, which there may or may not be. That's enough for jurors to understand the framework. And that understanding matters not because definitions decide the whole case, but because they help you understand the medical research and understand when the defense is trying to play word games with you. This has been Winning the TBI Case. I'm Tom Crosley.
If today's episode helped you see your current case in a new light, share it with a colleague who's facing the same challenges in a case. Subscribe wherever you get your podcasts and join our community of trial lawyers who refuse to settle for average results. This has been Winning the TBI Case: strategy, science, and storytelling with Tom Crosley.